There he is.
TalkShoe. Recorded live.
Hello, everybody. Just give me a minute. We'll get things quieted down here. Updates on my case in D.C. We get some updates on a new administrative court hearing here in North Carolina against the State Highway Patrol. So we got some news coming out here tonight, and there's some things that we want to discuss because I've done a series of shows here in the last several days, and we're going to get into some of that too. But for right now, Harvey, go ahead and do the updates, Harvey. We got some updates on this judicial conference. We may end up moving it over here to North Carolina. I got to find a place over here, an RV place, campsite, to have it over here because it looks like I am not going to be making any long-distance trips for a while because of this monitoring device that I have around my ankle. But if we can move it over here, I'm going to see if I can find some places that we could just do it over here. This way, it'd be easier for everybody instead of me trying to do via Skype and Skype in. We really need to be face-to-face. We need to sit down and talk instead of over an airwave on what we're about to get into and what we are breaking news on for these courts. Because, ladies and gentlemen, we got a lot bigger problem here than a lot of us realize and a lot deeper than most want to face. But first, I want to get into this North Carolina issue with the State Highway Patrolman. Even though I got railroaded in this court, I did file for an administrative hearing in Raleigh. Ladies and gentlemen, this goes back to this tort claim. For you new people, what's the first thing that you have to do? Do you have to have a charge against you? Absolutely not. Matter of fact, we need to start charging them. Just get pissed off one day and say, you know what, I'm going to sue the governor, and I'm going to sue the police department, and I'm going to sue the county commissioners. Why? Because I'm pissed. Did they do anything to me? Yes. They are living. They're breathing my air. They are taking pay, and they're not doing the job that they're paid to do. I'm pissed. And that's how it starts, ladies and gentlemen. You don't have to be pulled over. You don't have to be attacked by the thugs before you can go bring a claim. The fact that these people took a job and your verification on a lot of them is sitting down at the election board where these people applied for a job. And these other ones were hired in by them. I have filed several complaints into the governor's office, into the State Highway Patrol barracks, into the Attorney General's office, and into the Office of Risk Management. Under the tort claim setup, you have to go back and notify the agencies. You have to get them to bring you in and sit you down and say, okay, Mr. Class, my God, what's your gripe? What can we do to pacify you? What can we do to settle this? And you know they won't. This is what's going on with D.C. Point being of it is, the State Highway Patrolman thought he was cute. Hee, ha, ha, we can railroad you. Well, hee, ha, ha, I got an administrative hearing against him and the governor. For those of you who do not know, this makes my fourth administrative hearing, North Carolina, 3 of which I have had my case dismissed. But that dismissal was based on the court system coming back and stating that the police officers were private contractors and not agencies or employees of the state. That's what we want. The second one is when I went after this kid that I helped for this porn charge up in Charlotte, where we brought charges against the sheriff department, the county jail, the judge, the prosecutor, the police department, and the governor's office. At which point the administrative court came back and claimed that they don't work here. They're not a state agency. Therefore, the administrative court cannot address a non-government issue. That's a pretty favorable ruling. That's 2. Number 3, I went after the tax department here in Gastonia and the gas tax department in the state of North Carolina. Again, it came back. These are private individuals. They don't work here. I got 3 administrative rulings that says our government is empty. I'm going for the 4th because now I already went after the local police. I've already went after the sheriff department. Now I'm after the state highway patrol.
Now, Rob, was it the state highway patrol that pulled you over for the seatbelt violation?
Yep.
Okay, all right. So that, and this was all with your thing in Lincolnton. Just when was this? This was back in what, February? Yep.
Well, this is when I got pulled over, but it was just within the last month when we had our hearing on this.
Oh, right. Your regular hearing, and then you said, okay, I'm going to go for the administrative hearing. Well, you already had gone in for your administrative hearing at that point. In other words, you had already applied for it. You hadn't gotten it yet, right?
Yeah, I didn't get it yet. I got a case number, but it wasn't confirmed yet. Well, it now have been confirmed.
Oh, good. And when is that hearing again?
September 1st.
Okay. And so you're going to go up in Raleigh. You're going to bring this highway patrol guy in for an Office of Administrative Hearings hearing, right?
And the governor, yes.
Oh, and you're subpoenaing in the governor?
Yep.
Oh. Because he's theoretically his boss.
That's the whole key here, ladies and gentlemen. That's exactly what we're trying to get across to you, is the fact that we need to go after their boss and their employee. This is what the tort claim is all about, is going after who is in charge of the administration, ladies and gentlemen. This is what it's all about. I just got notified that September 1st, we're going to have a hearing on this. They're going to let us know 15 days ahead of time for sure exactly where it's at, whether it's going to be in Raleigh or whether it's going to be in some other court system down in this here area. Within 15 days before it happens, we'll find out. Now, ladies and gentlemen, I have been busy, not only dealing with this D.C. case, but going after the tort claim side of this thing. I am telling you this because of what we're going to discuss here tonight, is that these courts out here, and I see some comments up here where these courts are under admiralty. If you were correct, then we ought to be able to walk into admiralty into any of these courts and win 100% of the time, every time we walk in. If you're sitting here saying that they are probate, then you and I ought to be able to walk in with probate and win 100% every time. If you're going to sit back and claim some other type of jurisdiction, then we ought to be able to walk in every time and win it. Now, I realize guest 10 is saying it's about the jurisdiction. The problem of it is they're not telling you the jurisdiction. See, that's the problem here. They got 101 jurisdictions. I want you to guess which one, when you walk into that court, that he's going to run you under. Take a guess at which 101 he's going to run you under. Ladies and gentlemen, there's no such thing as 101 or 1,001 or 10 trillion to 1 jurisdiction. There's only one that they're supposed to be running under. That's our problem. This administrative hearing, because we are invoking this, we're setting the jurisdiction under the treaty that the governor has with the federal government under the Highway Safety Act. We are setting the jurisdiction that the governor's office is supposed to be running under that constitutional form, under that 14th Amendment to that Constitution, to hold that public office. We are coming in and addressing the fact that if they are foreigners, then they do not hold public office, and they do not run for election on November 2nd and claim that they're U.S. American people, and then at 9:01 election night, they turn into a foreigner. And then for the rest of the 364 days and a half, they're foreigners. Ladies and gentlemen, this is what we're getting into, and this is why these SF-95s, you people have an opportunity to lay back and start charging the judge, the prosecutor, D.C. police, all the way up through the ranks. Start bringing claims. Start bringing a tort claim. The fact that they are breathing your air, the fact that they are living on this planet and living in this country, and they're not abiding by the agreement that they took, is enough to bring a tort claim against them. These people are servants. They're not gods, they're not lords, and they're not kings. They're servants. The servant is not doing the job that they were hired for. You do not have to wait until you get damaged. Like I said, this is my 4th administrative claim. This court's going to do one of 3 things. It's either going to be stupid, and they're going to come back and say the governor is not an agency to the state of North Carolina. He's not part of the executive branch. He's not the head administrator. They're going to come back and say the State Highway Patrol is not law enforcement. And I pray to God that's what I get. I hope that's what I get. Because that now goes back and proves what we've proved on the last 3. Nobody works here, and everybody's collecting a paycheck based on fraud. The other scenario is that we could walk in there, and we're going to be able to go after the Highway Safety Act that we don't need a driver's license, because we do not drive anything over 10,001 pound. We're going to be able to go back and push the issue of the federal funding fraud. We're going to be able to go back and push the issue that they're operating without warrants, they're operating without complaints, they're operating totally against the natural born order of what this country was founded on, which is what we're going to get into tonight, is that they are charging us crimes against the state, which does not need a victim. The mere fact that they have profiled you is enough to drag you in. That's why all this stuff that you guys are coming up with probate and admiralty and maritime, I'm not saying that you're wrong, but I'm sitting here saying I want you to open up your mind here tonight, because what you're going to hear here tonight may give you something to rethink, because the program that I did here earlier today was on Nuremberg, the Nuremberg trial. We're going to show some comparison between that and the United States, but we're going to go back and show you that the United States has been doing this long before Germany ever did what they did. And the difference between Germany and the United States is that Germany was a country. And when it went into Czechoslovakia and Poland and France and Belgium, it went into other foreign countries. The difference between them is we don't have countries in this. We have states. And D.C., being Germany, has walked into all 50 countries outside of its 10-mile square and has dominated it in the same fashion that Germany did during World War II, if you stop and think about it. Ladies and gentlemen, this administrative hearing, because this highway patrolman is being cute, but you don't have to have my address. I don't have to give it up, but you have to give me yours. Because if you don't give me yours, that's obstruction, and I could have you arrested for obstruction, but I don't have to give you mine. Well, I want to tell you what, I really don't give a rat's rip. As long as I mail it out to his office and he throws it in the file, I have proof, because it's tracked, that he was served with a subpoena. And I have a registration number that shows that he was served. I hope he throws it away. I hope he disregards it. Because now I got him for contempt. Because I could prove that he was served. And when this goes to the next level, and it will, when I serve him for a personal lawsuit, and I will, and he throws this one away too, and he will, I will have him in default because he failed to show up to defend himself in a civil suit. And when you fail to show up in a civil suit, you lose. This is how this works, ladies and gentlemen. By going after him administratively, all I want the court to do is come back and say he don't work here and he's not a public official. That's the best news I could get. Because now what this means is why the prosecutor in D.C. is keeping an ankle bracelet on me is because of this Lincolnton case. Well, he was convicted. He is, he is an habitual offender against law and order. Once I get the order from the administrative court that State Highway Patrol is not an administrative agency and they don't work here, that now puts this federal prosecutor on the hot list, because now I can go after him because he knew this. And he can't claim ignorance because he knows these people are not legitimate. Because after all, it's the Attorney General's office for North Carolina that's coming in saying that the State Highway Patrol don't work here. They're not part of us, even though they're under the governor's office. Ladies and gentlemen, we're opening up some doors here for you. We're laying out examples for you to turn around and start jumping on. Don't wait for them to jump on you. Jump on them. Start bringing these claims against them. Start bringing administrative violations against them, procedural violations against them, duty violations against them. As of today, Harvey and I are working on the 63rd, which we got out today, but the 62nd document that has been filed into D.C. 63 of them is what we have worked up to. Harvey's working on 62 right now. 63 went out because we're asking about the June 27th hearing. Is there or is there not a hearing? I need to know because they moved this thing to August. I got a phone call today because I told him I need to move it to September. And the public defender said, why do you need to move it to September, Rod? I said, because I have an administrative hearing against the State Highway Patrol in Raleigh on September 1st. He says, oh my God. I said, yeah. He says, yes, I did. He said, God, Rod. I said, yep. Ladies and gentlemen, if they think for 1 minute that I will go after State Highway Patrol and the governor, what do you think I will do with them on the SF-95? If I went after the city police and I went after the sheriff and the judge and the prosecutor and the attorney general and the county jail, I went after these people and I got a ruling. They don't work here. They're not part of the administration. I went after the tax department. They're private individuals. What makes them think that I won't go after them? Harvey has a word for that he sits down and tells me that I am.
That word.
What is that word, Harvey?
I don't know. You tell me. What is it?
Was it what you used? What the word? Tenacious.
Tenacious. Yeah. Yeah. You're like something grabbing onto their ankle and you won't let go.
Ladies and gentlemen, this is what it's about. Your freedom is at stake. Charging these people. So if they think for 1 minute that I will go after a state highway patrolman and bring administrative charges for misconduct. Now, for you new people on the line here, let me clear something up for you so you don't get a bad impression here. If I'm wrong and I do something wrong, I will keep my mouth shut and I'll take the punishment to a certain extent until it gets beyond reasonable. If I'm wrong, then I will sit here and take my hand smacking. But if I'm not, and I'm not wrong, I will dig in my heels and I will be like a pit bull. And once I sink my teeth in, I don't let loose. The word tenacious is the right word for me. Ladies and gentlemen, this is what it's going to take for you and I. This is what it's going to take in order to fix this problem. They're going to have to see that we are no longer going to be sheep and we're no longer going to be sheared. I wasn't a sheep to begin with, and the moment they brought the clippers out, they felt the teeth and the horns dig in. That's the difference between a lot of you and me. I was taught I own City Hall. I was taught that these people are servants. They work for you and I. I don't work for them. I don't get paid by them. And I don't wait on them hand and foot. That's not my job. My job is to make sure that they do their job right. And when they're not doing their job right, it's my job to come in and start ripping them. That's your job. We're showing you how it is done. Now, the problem of it is, like I said, is going to go after them. Got to be willing to do it. We need to start bringing charges against them. Like I said, the moment that statey stopped me, I had paperwork already filed into the administrative court. The moment he stopped me, ladies and gentlemen, that's the key to all this. You don't wait till a court date to make a decision. Well, I guess I better do something. The moment they stopped me, they crossed me, and I went after them. That's how this works. I've already got my letter back from the Justice Department telling me they're going to investigate my D.C. case. I already got a letter back from the Sergeant of Arms of the Senate telling me they're not going to get involved. I already got a letter back from the Board of Governors not going to get involved. This DC case, they're allowing it open for me to come in and sue them. I did a cross-claim that Harvey and I worked on. We got it in. It's sitting there. We're bringing claims against them. Part of what is happening here is that supposedly in the DC case, their witnesses happen to be on vacation in August or in July, and we don't want to interrupt their vacation. You know what? Too bad. You interrupted me. Now, you want to postpone this? Fine, we'll take it, and we're going to run it to September. Because once I get my administrative ruling on this, I will have 4 to go after them with and to bring this stuff up on. Now, let's talk about what is happening right now in all of our cases out here, and I want you people to think about something with a very open mind. A lot of what is happening out here throughout the years, and I'm not knocking because sitting back, and Harvey and I have talked about this, seeing what is happening here in this DC case, sometimes you actually have to get involved where you are on the chopping block, for you to start rethinking and reevaluating what's going on. Howard Griswold, one of the best ones out here. Constitutional man, one of the best ones out here. Their paperwork was impeccable. Cornforth, his paperwork is impeccable. What Gene Keating is teaching on probate has merit of what he is saying. Stuff on admiralty and maritime jurisdiction has merit. What I have been teaching you, we have backed, supported, congressional record, hard ink on paper, absolute proof. What is the one common denominator with all this? What is that one common denominator? The more I think about it, with what we are getting into, with what we have dumped into this case, and the response or lack of response that's coming out of this case. And I had a chance several nights ago to sit back and watch an old movie with Spencer Tracy in it called Nuremberg. It's about Nuremberg trials. And ladies and gentlemen, for those of you that are not familiar, there were 2 trials, one against the military. The second trial setup was held against judges, lawyers, prosecutors, mayors, police department, doctors, civilians for war crimes, crimes against humanity, crimes against peace. The thing that stuck out on this is the fact that people were profiled back at that time. Whether it was the Jewish people, whether it was the Catholic people, whether it was Protestants, whether it was old age, people were profiled. The fact that they were profiled allowed them to bring charges against these people for crimes against the state. The Nazi Party, the Nazi courtroom, they would use the state statutes or the federal statutes, country statutes, in order to drag them in, but there was no defense. This is part of the problem that we're running into and what I'm looking at, because with all the different things that's come across the board throughout the years, through what's being said, jurisdiction, 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 jurisdiction. You walk into that court and they don't tell you the jurisdiction. They will not acknowledge other than I have it. And I have not found a rule book that says I have jurisdiction and what the rules are, and I have it. I have looked up the criminal rules procedure. I've looked up the civil rules procedure. I've looked up the rules of evidence. We've got into admiralty, maritime, ecclesiastics, workman's comp, probate. The jurisdiction is what the judge decides that day in court. That isn't how this works, ladies and gentlemen. That is not how this works. What I am coming to the conclusion on and looking back and seeing how everybody else filed paperwork and seeing that there is no consistency in anybody's paperwork, and it includes mine. There is no consistency. Allows me to come back and believe and realize, and after seeing this Nuremberg movie and going back and listening to the Nuremberg trial, is that they are definitely running as under crimes against the state, because it's always the state that's in that courtroom. During Nazi Germany, pulling the gold teeth and pillaging and plundering the people at that time was the big deal. In the United States, 1933, the moment they made you and I an enemy of the state under the state of emergency clause, and they put a dollar value on you, that is no different than stealing the gold off of the people and their property. Absolutely no difference. Is that they put a price in order to embezzle. This comes into humanitarian violations because they're dragging us in, and there is no jurisdiction other than crime against the state because there's no remedy. But I talked with Harvey about some of this, and ladies and gentlemen, this goes back, way back in this country. This country committed war crimes long before Germany ever came about on what they did. This goes back pre-Civil War of the slavery that we had in this country. This goes back to the Civil War, where the District of Columbia, or the federal government at that time, 1968, came into the South at gunpoint, very much like Germany did to Poland, Czechoslovakia, Hungary, France, Belgium, at gunpoint, and took over the country and told the leadership, this is how it's going to work. If you don't like it, say so. We'll replace you because we're going to shoot you. This was set up during the Civil War of this country, long before Germany did it. The difference, ladies and gentlemen, is that this was a country with multiple states and not individual countries being railroaded like Germany did. And this was the outcry, because if Europe was set up in the same fashion that the United States is set up, there wouldn't have been the outcry, because he invaded individual countries. That's where the problem come in. Ladies and gentlemen, hold on a minute, Carl. Ladies and gentlemen, we bring this up to 1933. Well, bring it up before 1933. They did this to the Native Americans. They literally exterminated a huge population of the Native Americans in this country. War crimes. Put them on reservations, exterminated them. This country has a history of war crimes long before Germany ever came about. But sitting back and listening with what we know today and what we understand today, the United States hasn't done anything different than what Germany did, other than we're not doing it to other countries. We're doing it to our own states, to our own people. And we're sitting back and letting it. We're not uprising over this. We're not bringing claims. Up to this point, nobody was teaching. Nobody was knowing how. We are learning how to come after these people now. And it isn't a class action that you want to do, because the reason why, if you do a class action, once you get your case dismissed, everybody loses. You want to do this on individual basis and come in as third-party interveners and bring your own claim and keep this thing rolling over and over and over and over and keep hammering. If you do a class action, one ruling takes the entire system out on our side of the fence. That's the last thing you want to do. Ladies and gentlemen, because of the bankruptcy, because of the dollar value, and the fact that they're not following the Constitution in these courtrooms, they're not following the statutes other than to drag you in. They're not following admiralty. They're not following maritime. They're not following probate. They're not following UCC. They're not following international law. This brings you to the conclusion that we're being brought in as crimes against the state. And even on crimes against the state under military regulations, ladies and gentlemen, under Title 10, under the UCMJ, under 333, an occupying force is required to follow the Constitution and the federal statutes and the laws of this country. An invading force cannot use their law of their country. They have to use ours under the Geneva Convention. we read some stuff here earlier today on crimes against the state, and what we have come up with on this is, let me pull it up, because one of our listeners sent this over to me, and it gets in: an enemy of the state, also sometimes known as enemy of the people, is a person or a group of persons, society, or incorporated entity considered in conflict, state of war, with the political of the government. Ladies and gentlemen, let's change the word Jew to sovereign. Let's change the word Catholic to constitutionalist. Let's change the names to what they are putting us in under a profile. The crime is still the same. The attitude, the mentality is still the same. The names have changed. According to their doctrine, the purpose of having a license, for you people who do not know, if you will look up in Black's Law Dictionary, a license gives you permission to do something that you would ordinarily be not allowed to do. So a license gives you permission to break the law, according to their legal definition. But what does this mean? Well, if I have a driver's license and a school zone is 25 mile an hour, I can add 125 mile an hour to that 25 and zip through there at 150 because I got a driver's license, and that license allows me to break the law, because if I did not have a license, then 25 would be my speed limit. As stupid as what that sounds, look up the definition in Black's Law for license. It gives you permission to do something you would not normally be allowed to do. It allows you to break the law. That's their phrasing. But ladies and gentlemen, we're trying to keep an open mind here with you on this stuff. I want you to sit back. I want you to think about what is going on, because what I have done throughout the years is I have looked at what other people have done. I have looked at, okay, what one thing is consistent with all this, with one thing that is consistent. And what is consistent is that everything that these people have done is not consistent with the court system, because there is not one thing that will get you through every single court case guaranteed that the judge will dismiss it every single time. This is what is coming up with what I am starting to realize, and my line of thinking goes right back in the fact that we are listed as enemies of the state through the state of emergency. And because the state of is in that courtroom, it is crimes against the state that we're being charged with. This is going to have to be addressed by you and I, not only in these court hearings, that we need to make these objections and make our voice heard, but also under administrative claim of notifying the offices and then charging them and bringing a claim against them federally to sue them. We're trying to do this in a very peaceful manner of addressing this stuff on what we're doing and how we are doing it, because it needs to be done on a peaceful means. What I'm going to pull up here is what we have talked about on these tort claims. And this falls back under Title 28, which is Judicial Procedures under 2672, Administrative Adjustment of Claims. The head of each federal agency or his designee, in accordance with regulations prescribed by the Attorney General, may consider a certain adjustment determination, proposing and settle any claims for money damages against the United States for injuries or loss of property or personal injury or death caused by the negligence or wrongful acts or admission of any employee of that agency, which acting within the scope of his or her employment under circumstances where the United States, if a private person was to do this, would be liable to the claimant in accordance with the law. The key is that we have to go after the administration. Through experiments here in North Carolina, we found the direction. The governor is in charge of all agencies, bar none, when it comes down to the state level. county commissioners is in charge of all county agencies, bar none. The mayor and city council is ahead of the city agencies, bar none. So once you hit the governor up, because he's the one that brings in the federal grant into the political subdivision, and you turn around and nail the county commissioners, and you turn around and you nail the mayor on the side of this, you have now hit the administrative agencies. You now have addressed it. This is what we've been missing. This is what we are working on and going after. Ladies and gentlemen, it's going to take us to go do this. Bottom line, you and I, there is not an option here because they're not abiding by the rules. And the other issue is the fact that we need to go to the military on this, and that goes back to the address that I've given on a previous show. We're going to give it again to the Provost Marshal in Washington, D.C. at the Pentagon. It's Major General David E. Quatock, Q-U-A-N-T-O-C-K. That's Q-U-A-N-T-O-C-K. Provost Marshal, Commanding General, United States Army Criminal Investigation Command, 2800 Army, Pentagon, Washington, D.C., 20310-2800 is the address. We are under state of emergency. He is provost. He is in charge. It's going to take us to start launching complaints and forwarding our administrative complaints into him that these people are not doing their job. Now, ladies and gentlemen, I want you to sit down and openly think about what we're talking about here tonight, because all these things that we are doing under Admiralty, under UCC, under Maritime, even under the bankruptcy, under probate, under international law, does not have a high rate of success. And there's only one reason for that. And that one reason is because none of this is what they're running under. They're bringing us in on crimes against the state, and they're not telling us this. And that's why we're using the state of in this courtroom. Let me bring in Carl here a minute. He has his hand up, and I wanted to get this out before I lost what I was going to sit here and say on this. Carl, go ahead. Carl? Hello.
Yeah, can you hear me?
Yeah, I got you. Go ahead.
Yeah, I'm standing here in the cabin, holding this phone by the window, having connection problems, people. Did you mention anything about what we talked about earlier?
Yeah, go ahead and bring that up again, because I did tell them we're going to try to do it over here in North Carolina.
Okay, people, take down my email. Now, I don't know who's all's on here, but back when we started this idea, I received approximately 25 confirmations from people that would be willing to come to Oklahoma at the lake and do a lake-type seminar. Rod and I discussed it. He cannot travel outside of North Carolina. So there's an opportunity to go to North Carolina. There's a place down there for campsites, etc. Rod's going to be looking at this within the next week or so. We're thinking maybe 30 days out here where we can confirm and set a new date. Everybody that's interested that will be willing to go to North Carolina, we can do carpools or whatever from this direction. There's some people in Florida that's probably going to be coming up. I think there's 2 down there, and some from up north. So send me an email. Let me know if you're still interested. And we're going to do this in North Carolina. Rob said there's a campground down there and a conference room at one of the hotels. So my email address is privategeneral@hughes privategeneral@hughes.net. That's basically all I have. I'm still in healing process with my operation, and I'm doing pretty good, coming back slowly. But I'm excited. I'm getting more excited, and I know some of you requested campgrounds, and then there's plenty. I've in Lincolnton, which is just down the highway, and there's some nice places down there. There's some nice hotels. So send me an email if you're still interested. We need at least 50 to 60 people to do this. We'll do it on a Saturday, Sunday. Might take Monday for one-on-one consultations like we used to do the other seminars in the past. But, you know, there's some new stuff that I can share. We can go through our court cases, your court cases, and, you know, it's an interesting time. I mean, we get involved. It's one-on-one, and like some of you have heard us talk about through the years, is just different than being on TalkShoe. So that's all I got for now. If I think of something else, I'll come back in.
Okay, thank you. Ladies and gentlemen, go ahead and mute yourself out, Carl. This way I don't have to. Okay. Ladies and gentlemen, because with what is transpiring in D.C., I have zip-folded Harvey all of the documents that him and I have worked on for D.C. Like I said, we made 63 as of this week. They're not all on Pacer. They're sitting on a lot of them. That is the point. The point is the amount of information that we have put in of exposing. And a lot of what has transpired through these court hearings. For example, let me pull up the one document that we just did here, and I read it here earlier today on what was filed in, and we actually got a federal judge to come back in because we challenged at another court case the United States Code and their validity. We actually challenged that puppy. This judge came back and gave us a response to that document, stating in there, in his document, that the federal statutes, USC codes, were not laws. The United States Code is not law. And he gave a case cite on that. And it is Green versus the United States, 2006. If there is a variance between the United States Code and the statutes at large, the statutes at large are controlling. Ladies and gentlemen, I've been telling you that for a long time. This is what we're coming back in, and we're nailing them on, is on this gun charge under Title 18, 921, the word firearm and the word person. They want to dodge this. But we're coming back in and saying you have to comply with the federal statutes. Ryan versus BILBY. Go by 1985. Although the United States Code generally omits an acting provision and other material, including in the statutes at large, this does not render the statutes at large ineffective. Again, they are referring back to the statutes at large as being the controlling factor. The United States, and I'm going to spell this word out because it's almost like Rumpelstiltskin. It's RAMANAUSKAS. The United States versus 2005. Although the United States Code is prima facie of evidence of the law of the United States, it is not the law themselves. Rather, the laws are codified in the United States Code, providing the public with a usable collection of federal laws. Ladies and gentlemen, we got 3 case laws that a federal judge handed us that goes back in and verifies exactly what we sit here and have stated on this. That you have to come back in and you have to refer back to the statutes at large as the ruling law in that courtroom, because the codes are taken out of context and are vague for what they are. This is what we are sitting on, ladies and gentlemen, for information. This is what we're putting in, why they don't have the jurisdiction that they're claiming. Perry versus United States is another essential case law from 1935. And they don't want you using this one because anything prior to Erie Railroad versus Tompkins, they don't want it used, and here's why. Perry versus United States has quite a few quotes in it. It says, the right to make binding obligations is a power of sovereignty. P. 294 U.S. 353. The sovereignty of the United States resides in the people. The sovereignty of the United States resides in the people. And Congress cannot invoke the sovereignty of the people to override their will as declared in the Constitution. P. 294 U.S. 353. When the United States, with constitutional authority, makes contracts, it has rights and incurs responsibilities similar to those of individuals who are parties to such instruments. This is getting back about the bankruptcy of 1933. This is getting into that HJR June 5th, 1933. The power given Congress to borrow money on the credit of the United States. Where you heard that before, ladies and gentlemen? Credit of the United States. Isn't this what Lindbergh brought up? Isn't this what McFadden brought up? The power given Congress to borrow money on the credit of the United States is unqualified and vital to the government, and the binding quality of the promise of the United States is the essential of a credit pledge. Section 4 of the Constitution of the 14th Amendment, Section 4 of the 14th Amendment declares that the validity of the public debt of the United States authorized by law shall not be questioned. It is confirmatory of a fundamental principle applying as well to bond issues after as to those bonds issued before the adoption of the amendment, and the expression validity of the public debt embraced whatever concerns the integrity of the public obligation. Ladies and gentlemen, some of the information in Perry versus United States and some of these other ones that we have, and let me go back through and let me see if I could pull them up for you, was it Nortan, N-O-R-T-Z versus United States, 1935, is another vital case that gets in and talks about the public debt, talks about the gold, it talks about the 1933 June 5th HJR obligation of the United States. You have United States versus Banker Trust, 1935. Again, this gets into the bankruptcy. This exposes the obligation of what is supposed to be happening here, of what they're supposed to be doing. And then you have another one, which that one and this one coincides with one another to where they run parallel of what they're talking about. And where's it at? Can't believe I might have passed it. Norman versus Baltimore and Ohio Railroad. It talks about bonds and gold coins, weights and measures. It talks about equal value, is that according to the congressional records, everything was 100% for 100%. If you had a gold certificate, whatever the price of gold was the exchange rate. What they did here is whatever the price of gold was, they gave you the rate in Federal Reserve note. These cases are significant of what we're talking about. This is why they don't want us going back into this. Problem of it is this. If you don't want me to go back this far, then we're no longer under the bankruptcy clause. So now you got to be honorable, and you can't use my name and my signature for collateral. You can't have this both ways. Ladies and gentlemen, these are issues that need to be brought up administratively. And ladies and gentlemen, you are the ones who need to bring it up. You're the one who needs to bring it up. If you don't, who will? This is the significance of what we're trying to teach, educate, and get you up, people up to speed, and to get you to think outside of the box. I've looked back of what other people have done, including myself. Look back and says, okay, these were the points. These are the keys. What was missing here? What is the system not doing? Where is there an inconsistency? Because like Harvey and I sit down and talk, the law of nature never changes. You throw a rock up in the air and it's not going to stay in midair. It's going to come down. You break a water balloon and the water don't stay in midair. It drops. When shit hits the fan, it scatters. We have rules and regulations that these people came in and took these jobs under a fiduciary duty of honor and integrity. The rules of court, and this is something that we have discovered and we brought out to some of you, and Harvey and I are talking about it now on this later paperwork that we're doing. What you and I have not been told is that under the rules, we're required to file an interim appearance before the court. The second issue, Judge Kessler has put it out in the paperwork. Again, they are telling us in the paperwork that we have to have pre-trial statements. Pre-trial. You get a traffic ticket, you're drug in. There's no interim appearance and there's no pre-trial statement. You walked in and your plate is empty for a defense. This is why I keep telling you people, you got to file paperwork in. Under Rule 16, Civil Rules and Criminal Rules Procedure, pre-trial. Under Rule 12, Criminal Rule Procedure, pre-trial motions. Ladies and gentlemen, before we walk in and have a trial, you and I are supposed to be filing paperwork in. You and I are supposed to be sitting here why this case should be dismissed. We're not being told any of this. Their side's withholding this information. Harvey will sit down and tell you after going through this docket number 90, Kessler have gave us a load of information that we have been missing out on because, number one, we don't go to college and we're not being told. So because we're not going to college, we're not being told, we don't know their entire setup of what they're doing. But you and I should not have to go through all this. Number one, they're required to have a warrant. They don't have. They're required to have a complaint. They don't have. They're required to have an injured party. They don't have. This is part of the qualifications of what we are talking about on some of this paperwork, of what we are doing, is the fact that we're now coming back in and we are pointing out the flaws of what they are not following, understanding. And standing has a huge requirement on their side of the fence of just what and how they're supposed to come into these courtrooms. They have to meet certain qualifications for them to come in and have standing against you and I in that courtroom, and they don't have it. The federal courts automatically, according to case law that we have come across, automatically forces these district courts, federal district courts, into a Article 3 setup. The requirements for standing in these courts is, number one, injury in fact to the plaintiff. This isn't just civil, this is criminal. There has to be a substantial injury to the plaintiff. There's never a plaintiff in the courtroom. It's always the attorney. It's always the prosecutor. He cannot put forth any evidence of an injury other than statutory violation on your side of the fence. Well, you broke the law. Okay, what was we talking about here earlier? Crimes against the state. You broke the policy. Crimes against the state. You broke the statute. Crime against the state. There's no injured party. Cognizance of the injury caused by the defendant. Complaint of conduct. How did I harm the state by violating your statute? Well, Mr. Class, you had a firearm. Excuse me, I got a license. I got a permit. Under your definitions of license, if I have a license, then that allows me to have it, and that allows me to carry it out in the open and carry it into federal buildings because I have a license. Now, if I did not have a license, according to your definition, then I could not carry it. But because I got a license, I now can carry it openly. Matter of fact, because I got a license, I can use it. Let's go back and use their logic. Point being of it is, there's three criteria here. They have to show up substantial injury. They can't. Therefore, they're charging you because you violated a policy. That's crimes against the state, ladies and gentlemen. Think about what we're saying here. They can't make any connections where I injured anybody. Third, a likelihood that the request relief will redress that injury. How is putting you in jail going to give redress for an injury that never happened? Nobody was harmed. So how is going to jail going to give redress? These are things that we need to think about seriously, ladies and gentlemen, of why we're coming back in and we're talking about crimes against the state. That this is a logical concept of what we're looking at. Like I said, getting involved into this on my own and me having to come in and defend and cover my own butt on this puts things into a different perspective of what we are looking at and of how we are going after it. Because also with what we have found in all these documents of what we are bringing forth to you is that Donahue case that is in Title 28 that deals with the District of Columbia. And that O'Donoghue case, if you go back and read this, what this gets into and explains is that the city state courts for the District of Columbia, the judges, not the federal judges, even though they are federal, but they're not in the United States District Court, they're in the D.C. court. These federal judges have term limits of what they could work, and their wages could be diminished at any time for reduced pay, and there isn't a thing that they could do about it. Under this O'Donoghue case, what they did is they brought suit against wanting equal pay for equal standing as a federal judge. Under Article 3 of the Constitution, so that their wages would not be diminished and their job would not be diminished because they would have a lifetime job as a federal judge sitting in the District of Columbia in their state courts. So they wanted that Article 3 standing. In order to have that, they had to agree to be an Article 3 judge. And that's something that we missed out on. That's something that we did not make the connection on until I found these case laws on this, which is a very significant find, because now these judges can't claim any other jurisdiction than Article 3, because we're going to set them into that, because we're going to set it up that this is what they have to come into. Because what it explains here in this one case law, it's got assistance of data process serving origin versus camp. The question of Article 3 standing is relevant only to whether the dispute sought to be adjudicated will be presented in an adversarial context and in a form of historical view as capable of judicial resolution. Whitmore versus Arkansas To suffice for Article 3 standing, an injury must be a harm that is both concrete and actual, or imminent, not conjecture or hypothetical. They're going to come in, these courts have to come under this guideline. Linda R.S. versus Richard. Essentially, the standing question is, such case is whether the constitutional or statutory provision on which the claim rests properly can be understood as granted person in the plaintiff position a right to judicial relief. Again, there has to be an injury. No injury, no claim. Again, we're getting back into what it sounds like they are claiming here falls back under claims or crimes against the state. If we stop and think about the logic on this, we stop and think about what they're doing and how they're doing it. All these different case laws that they have here gets in and states certain guidelines, but they're not following them. They're making them, but they're not following them. This is why I'm getting into the line of thought here that all this is coming into crimes against the state. And ladies and gentlemen, they have to come under the UCMJ, because the only way that you can have a crime against the state is under military occupation. Under military occupation, we have been taken over. Or if we are under a communistic setup or Nazism. Germany got away with this for quite some time. They thought they were going to have a 1,000-year reign. Little did they suspect that it would be cut down to 5 years, and then they would be tried and convicted. The Nuremberg document that we're bringing up in here in this jurisdictional challenge comes in and addresses several different things here, along with federal law that coincides with it. Under Nuremberg trial final report, Control Council Law number 10, punishment of persons guilty of war crimes, crimes against peace, and crimes against humanity. Any person without regard to nationality or the capacity in which he acts is deemed to have committed a crime as defined in paragraph 1 of this article if he was 1. A principal, 2. was an accessory to the commission of any such crime or ordered or abetted the same, took a consenting part therein, was connected with planning or enterprising involving its commission, with a member of any organization or groups connected with the commission of such crimes, or with reference to paragraph 1, if he held a high political, civil, or military, including general staff position, post in Germany or in one of the Allies' co-belligerent or satellite or high positions in financial, industrial, economical life, or any such country. This takes you right down to the police officer out here on the street, snatching you off the road without a warrant, dragging you in to the court, and the court is selling us on the stock market and securitizing. He's now named in this. The lawyers are named in this. The mayor's named in this. The county commissioners are named in this. This Nuremberg trial breaks this stuff down, ladies and gentlemen. Now, let's go down to the federal laws on this, of what's being violated on their side of the fence. Title 18, 1001. Except as otherwise provided in this section, whoever in any manner within the jurisdiction of the executive, legislative, or judicial branch of the government of the United States. Well, that pretty much says it all. You just covered all three branches. Falsifies, conceal, or cover up by any trick, scheme, or device a material fact, making any materially false, fictitious, or fraudulent statement or representation. Title 18, 1621, is guilty of perjury and shall, except as otherwise expressed, provided by law, be fined under this title or imprisonment not more than 5 years, or both. Title 18, 1581, whoever holds or returns any person to a condition, appendage, or arrest any person with intent of placing him in or returning him to a condition, appendage, shall be fined under this title and imprisoned not more than 20 years. This also goes into kidnapping, extortion, armed assault out on the highway. These law enforcement officers know that you and I are not in commerce under the federal guidelines. They know about the money under the Highway Safety Act. They know about the birth certificate. And you can sit back and say, well, no, ignorance is no excuse. A lot of these guys know about this. They just don't want to sit down and say it. When they retire, then they, oh yeah, we knew about this. We just don't say it while we're on duty. Title 18, 1581. Title 18, 1584, 85, 1590, 1592, 1593. Title 18, 1346. For the purpose of this chapter, scheme or artificial to defraud includes a scheme or artificial to deprive another of a tangible right of honest service. Title 18, 19, advocating the overthrow of our constitutional form of government. Title 18, 23, 31, to intimidate or coerce a civilian population. This falls under the Patriot Act under Section 802. Title 18, 241, if two or more persons conspire to injure, oppress, threaten, or intimidate any person in any state, territory, commonwealth, possession, or district in the free exercise of enjoyment of any right or privilege secured to him by the Constitution or the laws of the United States. Title 18, 242, whoever under color of any law, statute, ordinance, regulations, or custom willfully subjects any person in the United States, territory, commonwealth, possessions, or district to deprive them of any rights, privileges, or immunity secured or protected by the Constitution or the laws of the United States. Title 18, Chapter 115, 2381. Whoever owing allegiance to the United States levies war against them or adheres to their enemy, gives them aid and comfort within the United States or elsewhere, is guilty of treason and shall suffer death. I didn't say that. That is written in their books. They commit treason, they shall suffer death, or shall be imprisoned not more than 5 years and fined under this title, and are incapable of holding another public office. Ladies and gentlemen, I didn't write this stuff. This is their writing of their restrictions, of their guidelines, of their duties, of what they're not supposed to do to us. Title 18, Chapter 115, 2382. Whoever owing allegiance to the United States and having knowledge of a commission of any treason against, then concealed and does not, as soon as possible, disclose and make the same to the President or some judge of the United States. This has been done. Title 18, Chapter 115, 2385. Whoever with intent to cause the overthrow or destruction of such government. Title 18, 641. Whoever embezzles. They are embezzling our trust. They're not paying the bills. They're not discharging the debt. Title 18, 873. Demands or receives any money. They are kidnapping us. They're forcing us to sign, and they are stealing out of our account. Title 18, 1201. Whoever unlawfully seizes, confines, decoys, kidnaps, abducts, or carries away on any person for ransom. Title 18, 1203, whoever within inside or outside of the United States seizes or detains and threatens to kill, to injure, or to continue to detain another person. Title 18, 1654, commits hostilities upon the citizens of the United States or their property. Title 18, 1661, whoever being engaged in a practical cruise or enterprise, this falls back under racketeering. Title 18, 1957, and the other offenses under such takes place in the United States. Title 18, 1959, whoever, as considered of the receipt of, or as considered for a promise or agreement to pay anything a punitive value from an enterprise engaging in a racketeering activity, or for the purpose of gaining interest to a maintenance or increasing position in an enterprise engagement in racketeering activity, murder, kidnap, maim, assault with deadly weapon, commits assault and serious bodily injury upon or threatens to commit a crime of violence against an individual in violence of the laws of the United States or the United States or attempts to conspire to do so. Title 18, 1961, racketeering enterprise. Title 18, 2112, whoever robs or attempts to rob another of any kind or description of personal property belonging to the United States. Ladies and gentlemen, the obligation of the United States falls under that bankruptcy. These lawyers, police officers, judges are dragging us in, and they are embezzling, creating a public debt of trillions and trillions and trillions of dollars. These bankers falls underneath this. Title 15, Section 7311. Oh, Title 5. 7311. Any individual may not accept or hold a position in the government of the United States or the government of the District of Columbia if he advocates the overthrow of our constitutional form of government, is a member in an organization that he knows advocates the overthrow of our constitutional form of government, participates in a strike or asserts the right to strike against the government of the United States or the government of the District of Columbia, or is a member of an organization of employees of the government of the United States or an individual employed by the government of the District of Columbia that he knows asserts the right to strike against the government of the United States or the government of the District of Columbia. Ladies and gentlemen, I just ran through A through Q of the alphabet. Constitution of the United States, Article 4, Section 1, 2. Constitution of the United States, Article 4, Second Clause 2. Bill of Rights, 1, 2, 4, 5, 6, 8, 9, 11, 10, 11, and 14. Title 36, Chapter 705. Ladies and gentlemen, the list of their violations is listed. They do not have anything on us as they have not met the qualifications of what they have done by charging us. This is why I'm coming back in. I believe that they are running us under crimes against the state.
Well, there too, Rod, the psychology, the psychological trauma that the persons in our government, that last part there you're talking about, you know, think about Bush when he signed that Patriot Act.
Yep.
I mean, he people don't know that. People can't understand that. And they go out here and they vote for these idiots and put them in office. Well, guess what happened to Cantor? The Tea Party came up here this past few days and got him out of the picture. You know, we're seeing little things happen, but stop and think about it. Bush is one of the overthrowers when he signed that Patriot Act. I'll mute out.
Okay. But we're giving, ladies and gentlemen, we're giving you some avenues to reevaluate of what is going on, because we're laying out that there is no consistency in any of our paperwork in this country. And you figured one of us would have a 100% consistency of walking into these courts. And I don't mean them walking in, I mean us walking in with their paperwork. Us walking in. There has to be a jurisdiction that we can address. Let me take a couple callers here. Hold on. Central Georgia, go ahead.
Hey, Rod.
Yes.
Well, last week I had my trial, and basically I subpoenaed the DA, I subpoenaed the chief judge, I subpoenaed the sheriff, I subpoenaed the officers that arrested me, and basically the DA filed a motion to quash so fast it wasn't funny. And basically they stated in their motion to quash that they had no personal knowledge. So I said I would stipulate to that they had no first-hand knowledge on the grounds that I would move to dismiss the complaint. Well, they didn't. They denied my motion to dismiss. So basically I had a jury trial, and the people literally had no clue. Asked the officer, did he have any bill of ladings? Did he find anything that I was working in commerce? Did I have any passengers? Freight? He denied that I didn't have any of that. Jury came back, found me guilty on all 6 counts. 2 counts of obstructing the officer, 1 seatbelt violation, 2 counts failure to register, 1 failure to register within 30 days being a resident, and the other one being driving with expired tag and a seatbelt violation. So I'm supposed to be sentenced Tuesday. So right now I'm in a quandary as to what to do and where can I go from here.
How long have you been on the show here today?
I've been listening the whole time.
Okay.
And let me say this right. You called out all of that, the Title 18. I was trying to keep up with what was saying. It would be nice if you could pass that to Harvey so he could send it out to the big list so that,
well, it is.
A visual.
It is, because it's going to be posted as one of the documents just as soon as it hits the court. But see, you're missing the one part here of the administrative charge that I talked about at the very beginning of this show.
Okay.
Bringing an administrative claim against them. Now, you can go back in and do a notice of appeal, stay of judgment, and go back and appeal this case based on the fact that you put a subpoena in. They came back and said they had no first-hand knowledge, and you can go back in and do an appeal on this.
So I want to do a stay of sentencing?
Yep. Notice of appeal.
Notice of appeal.
And a motion to stay of sentencing.
Okay, motion to stay. Okay. All right. Yeah, because I stipulated on that. And also, I called the state of Georgia as a witness. And the judge looked at me. He said, "Sir, there's nobody coming. It's an entity." I did a misnomer. I sent in a copy of the birth certificate stating that, I was a man. This is the defendant that you're looking for. I did the entrance of appearance as a living man. All of this stuff is in there. And literally everything that I threw at them, they just railroaded me.
Okay, again, this is what we are talking about here tonight, is that they are overriding. It really comes down to where we are being charged as crimes against the state, like Nazi Germany did with the
right.
Jews and all these other people when they put them in the concentration camp.
Yeah, absolutely.
This is what the point we're trying to get across, that this is really what we are up against, because you subpoenaed a admitted that they have no first-hand knowledge, but yet you were convicted by the prosecutor who had no first-hand knowledge of the incident.
Exactly. And it's so funny, Rod, because when I tried to, because I'm not an attorney and I'm not as good as you, but I'm telling you, there's one code in there about the seatbelts. If you have a doctor's note, they switched the prosecutor. Also, the prosecutor that was there wasn't the original one. So can I also use that as grounds for appeal, too? Because this guy, he didn't put in an appearance. He just showed. Okay.
You have avenues here. Go in and do a notice of appeal, stay of judgment on this. If you wait until after sentencing, you might as well go to jail.
Right. So put this in Monday.
Yes.
Make sure you put Crawford versus Washington, U.S. Supreme Court decision on exactly what you're talking about.
Crawford versus Washington?
Crawford versus like Joan Crawford? Crawford
right.
versus Washington.
I got it. Versus Washington.
Yep.
Okay. I will put that in there. Because basically, like I said, I subpoenaed them, and nobody showed. In fact, they were supposed to be there on the 2nd, and the judge, the chief judge, wasn't there, and the officer wasn't there. So I should have actually, and I wasn't even thinking about it at the time, I should have actually had a bench warrant for them because they didn't appear. They were supposed to be there on the 2nd, and they never showed up.
Well, let me ask you a question. Who picked the jury?
We both did, but I objected to the jury because they weren't a jury of my peers. I objected to the jury, and I think I should have had the jury removed before I made that objection and the statement that the jury wasn't a thing. They weren't jury of my.
Okay, so they just ran some people in there on you, right?
Yes, sir.
Okay.
All right.
And then also the other point of it is, and I think this was probably a big sticking point, was the fact that there was a notice listed in the sheriff's office that we possibly might be sovereign citizens, and so I made the statement that that's an oxymoron. Sovereign is a king and a citizen is a slave. So because they were using that term citizen, the citizens of the state of Georgia, or the people of the state of Georgia, the citizens of Twiggs County, I think that might have biased the jury against me as well, because I'm thinking here I'm better than them, and I was just trying to make a very defining differentiation between a sovereign and a citizen. You know what I'm saying?
Yep.
That you can't be a citizen.
Okay, sounds good. Let me get to the next one. Thank you.
Thank you, Brad.
Yep. Colorado, go ahead.
Yeah, this is Nancy from Colorado. I have a judgment in civil court for a tax case. They did a summary judgment. They just ran over everything, of course, that you've taught us, and they used Celotex, which just says they need an assessment, but it's not a verified assessment. Now, I still could put in a 60B. Now, could I use this material from tonight and put that in there?
Yes, most definitely.
I don't really know how to write a 60B, but...
Go back in. Cornforth has had a lot of good information, and it's on the internet of what he has done.
Okay. Because, I was going to make the point, obviously, that the judges, how could I get a fair trial? I mean, how could I get a fair hearing when, they're making money off the case?
Well, that's exactly right. But see, again, this is where you could go back in and do that void order, do a reconsideration on this, and start bringing up again this stuff. But we need us, you, me, all these people on here. We bring in claims against them administratively on this. We need to bring in a tort claim
Yeah, but aren't they going to then have all their friends, the judges?
I don't care.
Yeah, well.
Because if the thing that comes down to this is that we need to take them into the federal court of claims or the state court of claims. If it's the state level, we take them into the state. If
well, this is a federal, you know.
But we have to start notifying the IRS. We have to start notifying the feds. Whoever is trespassing on us, is that we have to start going back in and demanding an administrative hearing with them under this Title 28, 2672. We want an administrative hearing, not a trial. Don't drag my ass to court.
Yeah, I've never had an administrative hearing.
And when they don't do this, then we can bring a claim. But when we notify them, we have to send either a registered mail receipt from the post office that shows that it is registered, where they have to sign for it, or we have to do this by certified mail where they have to sign for it, or put a certified mail with a green card return receipt, so we have proof of when it was sent, when they received it. So now when we bring a claim, here is my evidence that they did receive it. Here's the proof that I did notify them. They didn't do their job.
Well, I've been told by the post office that they don't accept registered mail, but they will be certified, and I've done many certified things. In fact, I did a claim that the IRS should be under Title 15 because they're a debt collector, and I got the green card back from the commissioner of IRS. However, he didn't give an answer to my claims. He sent things apparently to like Fresno and Utah, and I got letters and said, we have received a request from you for information, and they don't say what it is, and they say we'll get back to you in 45 days, which anybody who's ever dealt with the IRS knows they never do that. And I did not even get the green card back from the Secretary of Treasury.
Okay, now, remember what we're saying here on this tort claim. Let me pull it back up here, because this tort claim is a very significant, what they're getting into. It's telling us what we need to do and what we have not been doing. We have not been following up on a lot of this stuff.
Right.
And they don't respond back to us. They have 6 months. They got 6 months to contact us. If they do not contact us within 6 months, they have given us permission to bring a tort claim. What we have been doing is, well, they haven't contacted us, so we threw our hands up in the air and said, well, we just lost. That isn't what it means. Under Title 28, USC Code 2401, time for commencing actions against the United States. This is your time frame. It sits here and says, any action shall not be instituted upon a claim against the United States for money damages for injuries or loss of property or personal injury or death caused by the negligence or wrongful act or admission of any employee of the government while acting within the scope of his office or employment, unless, here's the clincher, unless the claimant, you, shall have first presented the claim to the appropriate federal agency, and his claim shall have been finally denied by the agency in writing and sent by certified or registered mail. The failure of an agency to make a final deposition of a claim within 6 months after it has filed shall, at the opportunity of the claimant, you, anytime thereafter, be deemed a final denial. So if they don't answer, you consider they told you to kiss off the claim for purpose of this section. So now what this means is you now can bring a suit against them in the Federal Court of Claims because they failed to respond. They have waived their immunity. You're no longer suing the United States. You're now suing that private individual just like they're suing you. This is what we've been missing.
Yeah, you know, you're really right about the commercial law because I got a commercial judgment of default against them because they didn't respond to an affidavit.
So,
and they ran right over that. And they, you know, it should have created a estoppel and latches.
okay, because you did this,
Yeah.
they have not answered. If you send it out by registered mail where you could actually prove that they received it.
No, this was to the district court, and obviously they received it because it's on PACER as one of the, docket numbers.
Okay, now you have proof that it's been docketed, but did you send this to the court?
Yeah, I sent it to the court, and I sent, I also filed it in the county records.
Okay, now let me finish what I was saying here. You sent this to the court. Did you send it out by registered mail, or did you just put a stamp on it?
Well, I think I put a stamp on it, but it was docketed, and it is in PACER.
Okay, but again,
Okay.
listen to what it says here.
Yeah, you said I heard the certified mail.
Everything that I send to the court is certified.
Oh, okay.
Everything I send is certified. So now it is docketed with certification. So if they don't do, I have a claim. This is what we're getting into. Ladies and gentlemen, this is what we're missing here throughout all the years. And Carl and I talked about this earlier, that the one claim that him and Roger Tanner did, they took it right into the federal court. And for Federal Court of Claims, the Federal Court of Claims remanded it back. And the remanded it back was because they did not notify the agencies prior to bringing it into the Federal Court of Claims. And this is what we have been missing. When we get a rejection, we throw our hands up and say, well, we just lost. That rejection is a permission to sue them. That's what I'm sitting here saying with this administrative stuff that I'm doing here in Raleigh. When I am getting the court system, the administrative court, to come back in and sit down and say, Mr. Class, they are private contractors. The administrative court has opened it up that they have relieved the state of all liability, and for me to go sue these people in their individual capacity. This is what we're missing. We're not going that next step. When they deny, we throw our hands up and we walk away and say, we just lost. We didn't lose. We have now got the authority to go after these people because they're no longer protected by the state. Ladies and gentlemen, that's what we've been missing. And that's what we're sitting on now. And if I wouldn't have been stopped in D.C. at the time, I was working on this thing to go after, but now that they did, I have the State Highway Patrol, I have the 3 law enforcement officers, I have the administration. I now can open this thing up under the Highway Safety Act. We now can open this thing up under the bankruptcy and bring a claim against these people in their private capacity and sue them for breach of the bankruptcy and breach of the Highway Safety Act. Ladies and gentlemen, this is what we're sitting on. This is what we have in our arsenal of being able to go after these people. The moment they sit down and say, we're not going to answer, or they refuse under their laws, once we set this thing out, we have now nailed them. And we have bypassed it because we thought we lost, and we did not lose. We just didn't understand what we had in our possession. And that's what we're up against, ladies and gentlemen. So give it some thought about what we're talking about here tonight. You have the ability to go bring in IRS, and under them 4 documents of Perry versus United States, get into them, because the one in those documents says that Congress is the controlling factor over the money in this country. Congress is the controlling factor. There is your first administrative agency to notify. Go back and find out which committee you need to notify. Ladies and gentlemen, we're sitting on some answers here. We are sitting on some answers here. It's going to take us to go do it. It's going to take us to go push this. We are going to have to do it. Like I said, we've looked back, and I've walked away on some of this stuff in years ago, and I was waiting to get this thing set up for North Carolina. I got my 4th one. I got my administrative hearing for September 1st. Whether it's going to be in Raleigh or in some other county closer, I don't know for sure. 15 days ahead of time, I'll be notified, because they don't want it out until time comes. But ladies and gentlemen, we now know how to do tort claims. And we know how to go after them. And we need to start doing it and quit being a victim in our own country. We need to start being aggressive here and start suing them. All right, I want to get in. I got one more. I'm going to take one more call here. Ray, go ahead, Ray. Ray?
Yes, I just wanted to, and I'll be brief, invite y'all to sign a survey at this one place called National Whistleblowers .org. That's nationalwhistleblowers.org, and sign a survey. When you do go there, you'll just click on Take Action, and then you'll see where it says Current Action Alerts. And it has to do with IRS and how they want to take away the whistleblowing pay if they pursue it as a crime. But they say you can still, get it if it's in regards to civil or administrative agencies. And so I just wanted to invite y'all to take a look at that, because that's going to be very informative. That's it.
All right, thank you.
Thank you. Bye.
Yep. Ladies and gentlemen, like I said, tonight I want you to, we need to back up and reevaluate the fact that they are bringing this in as crimes against the state because of what we're looking at. There's no consistency on winning in these courts. And the fact that they're suppressing everything, and this one gentleman admitted he subpoenaed the state, and the state doesn't exist. He subpoenaed the prosecutor, and the prosecutor has no information. Well, if he has no firsthand knowledge, then he can't be in there prosecuting, because that means that he does not have a plaintiff. These people are giving us the answers. We just need to start thinking outside the box and going after this. We've been on it for 2 hours. I'm going to go ahead. We're going to call it a short night for tonight, ladies and gentlemen. I will check into these RV parks around here to see if what I can find up. There's one that is a beautiful place, but it's just across the border, and I can't get across the border on this with this ankle bracelet, and that would be the perfect place to have it. So I'm going to check at some of these other RV places around here for campsites, see what we have, get the conference room set up, and we'll let Carl and I will talk about it. We'll let Harvey know. We'll get this thing posted out. But ladies and gentlemen, think about what we're talking about here tonight is the fact that more than likely we are dealing with crimes against the state because nothing seems to be working in these courts consistently. And you cannot have a 99% conviction rate on their side of the fence if we had some type of legitimacy within the court system. Thank you. You guys have a good night.
Thank you, Rod. Thank you, everybody.
Thank you.